This is the classified documents case that was brought by Jack Smith out of D.C., but it had to be moved jurisdictionally to Florida. And it's Judge Eileen Cannon who's dealing with this, who's a Trump. They're so angry that she's delaying the trial that she's actually considering these substantive defenses and grounds here. Trump has moved for dismissal on presidential immunity.
On 4 different grounds. So the other 3 are that Jack Smith has no authority, and this is also pending before the Supreme Court of the United States.
This was the amicus that the interveners filed in the Supreme.
And now there have been more amicus, including amicus by people who have a public record of hating Trump, who have said that this cannot happen. You cannot have the entire prosecutorial power of the United States government handed over to a private citizen who's never been confirmed or even nominated by the president, least of all confirmed by the Senate. That you just can't, no one can have that degree of power. The way I used to put this issue when it would come up in some context and I was seeking a dismissal or some other legal remedy, they said, why is it that the janitor who's employed by the federal courthouse doesn't have the power to walk into a grand jury and indict people? It's because we have strict limits on delegations of authority, and that original initial authority has to come from a person nominated by the president and confirmed by the Senate. All the other prior special counsels have been special counsel either appointed directly by a congressional statute through an independent court system, or they were appointed as U.S. attorneys. And in other words, they had already been approved of by both the president and the Senate for the prosecutorial power of the federal government as a United States attorney. And all that changed is what jurisdiction they were given, as opposed to jurisdiction limited by geography that was extended to a particular subject matter. That's not what happened here. Jack Smith was not a United States attorney. He was a deep state hack working over in the international courts, covering up corruption over there on behalf of various deep state actors and often complicit in the corruption himself, according to various whistleblowers. He was chosen because they needed someone that they knew would prosecute Trump. Biden believed his own U.S. attorney appointees would not prosecute Trump, which is very revelatory. That means that none of them were willing to jeopardize their professional futures on a rogue prosecution that crossed every Rubicon and burned every bridge to due process of law in America. And so the first issue is whether or not he had the authority to seek a grand jury indictment in the first place. And if he didn't, then the indictment has to be dismissed. And so they're challenging that on the same grounds as is pending before the Supreme Court of the United States on the Meese and other amicus briefs. And that is, he's a principal officer because he has the power of a principal officer. And as such, he had to be confirmed by the Senate. He wasn't. There's also issues about whether his funding was properly done. It appeared to have been done in direct breach of congressional limitation, which would create a separate and independent grounds to dismiss the indictment. The second grounds to dismiss the indictment is the Presidential Records Act, on the grounds we talked about from the very inception that have now become part of the common arguments. They weren't the arguments originally raised by Trump's team. They are now. And that is that the president has complete non-reviewable discretion while he is president in determining whether a record is a presidential record that has to be preserved in a particular manner or is a personal record that's his to do with as he fits. That determination is non-reviewable, as the courts have ruled previously.
But now, this was one of the things they made fun of him about, where he says, I can just think it and it becomes declassified. There is, and I thought there was a formal process. There is no formal process for declassification. Him taking
there never
it
has
home.
Been. Here, exactly, the very act of him removing it from the White House, not sending it to the archives, and sending it to Mar-a-Lago was a determination of personal record. I mean, Bill Clinton never made an official determination that the record, that the tapes in his socks drawer were personal records. There was no written documentation of that. There was no written determination of that. He claimed it. He said, it's in my sock drawer, so by definition, it has to be a personal record. That act constituted the decision. And that because he did that original act while president, that meant it was non-reviewable. That and the federal courts agreed. Same federal courts, by the way, eager to lock up people on January 6th and hate Trump now and trying to change the law to screw Trump. Back when it was Clinton on the hook, said clearly he has complete discretion. And that's the historical record. The historical record is presidents can keep their own records. That goes all the way back to George Washington. And what's interesting is they cite the Hur report in the motion to dismiss. They say the Hur report makes this precise point. When they're trying to let Biden off the hook for things he did while vice president, for things he did while senator, when he did not have the same presidential power as the president does under the Presidential Records Act. It went out of the way to talk about how common this was done by presidents without legal consequence, including by Obama, including by the Bushes, including by every president since George Washington. And they're citing the Hur report, saying this is additional grounds that requires and compels dismissal under the Presidential Records Act. While he was president, he made a non-reviewable decision that cannot now be challenged and questioned by prosecution. In addition, they point out one of the things we pointed out from the get-go that I'm glad to see is now part of their repartee, which is there is no criminal remedy in the Presidential Records Act statute for a reason. If they wanted criminal punishment to be an available remedy, it would be there. This is analogous in many cases to the Amos Miller case, where what the remedy, if you're not licensed or permitted to be a retail food facility, for example, in Pennsylvania, he doesn't meet the definition of a retail food facility, but even putting that aside, is a summary fine of $100. That's what he was previously told, by the way, by the Pennsylvania Department of Agriculture. They didn't say we can come and seize all your food. We can come and destroy all your food. We can come and shut down your farm, because that's not what the law said. So they just decided to usurp it, much as here. There's no criminal remedy in the PRA. The archives has previously taken a contrary position to the one they're taking now. So their point is that even if there was somehow a violation, even if this didn't give him the authority, they can't criminally prosecute. There's a civil recovery mechanism in place. That was the only mechanism the Congress wanted, that could be enforceable. So that's independent grounds to bring in the motion to dismiss.
And this is analogous to the Ethics Act or the Conflict of Interest Act out of Canada, is that it provided remedies, none of which were criminal in sanction. And everyone's like, well, it's got no teeth. No, the whole idea was if you get found to have been in violation of it, the consequences would be political and not criminal. And it sounds rather analogous. Okay, sorry. And number 4.
4 is immunity. And third is vagueness. Their point is that if the law can be interpreted, the Espionage Act can be interpreted to apply to a former president who took his own records home, then clearly, as applied to him, the law is void for vagueness. The reality is the espionage law should have been struck down by an honest court a century ago, when they first passed them during World War I. They were misused and abused then for politicized purposes. I've opposed the law from the inception. The problem, and the courts have gone to great lengths to try to salvage and save the statute. But the fact they've saved it and salvaged it in other cases where it was much more of an analogous fact pattern that the law was trying to reach, clearly it applies to the former president taking his own records home while he was president. That's now espionage? Espionage? It's absurd on the face of it. And so the point is that if the law can be interpreted that broadly, then it's void for vagueness. Because when a law is so broad that it's subject to the whim of a judge or prosecutor as to what it means and who it applies to, then it is so vague that it lacks limits on the discretion of the executive branch. And under the rule of lenity, has to be found as void for vagueness under the Constitution of the United States. You have to be put on specific particular notice that if you do A, B, or C, that you can be criminally prosecuted under that statute. No one could have been in Trump's position under such notice. Well, unauthorized, what does that even mean? Relating to national defense, what does that even mean? Right to retain it, what does that even mean? It's preposterously broad, and it was deliberately that way so it could be politically used to target dissidents. And it long ago, an honest court would have struck it down. And this court now is afforded a compelling opportunity to strike it down in the case of President Trump.
Espionage,
and that is all before you get to immunity.
The espionage. What foreign government? They presumably have evidence that he was providing this to some foreign government, or was it with the intent of?
Their interpretation of the Espionage Act is that that's not required. Mm-hmm. All that's required is you have it and you aren't authorized to have it. And it relates to national defense, which is extraordinarily broad. And that's the problem, right? The law was always too broad. It was always, but they usually used it of someone who took photos at a sub and shared it with people they weren't supposed to, et cetera. But they were always trying to push the limits. I mean, they used the Espionage Act to put Eugene V. Debs in prison for a speech against the draft. That's how asinine that statute was. And a corrupt Supreme Court approved it. So the Espionage Act has always been to target dissidents. It's never really been intended to target actual illicit spying, actual treasonous or seditious behavior. There are other statutes that actually cover that much better. But it's the same thing they're trying to do to Julian Assange, use in part the espionage to go after him. Because, it's unauthorized documents related to national defense. I mean, it's preposterous in its breadth. And so consequently, this is as compelling an opportunity as any to find it unconstitutional as applied, at least here. If not just unconstitutional from the get-go. It's always been too void for vagueness. Well, then the last ground they brought is the immunity grounds, and that corresponds to what the Supreme Court is dealing with. And I'd got some pushback when I originally said the Supreme Court ruling on immunity could end almost all the nonsense. But in fact, it would, because it would if the Supreme Court says the president has immunity from criminal prosecution for anything he did while president, at a minimum, unless he is successfully impeached and convicted for that action, then that requires dismissal of the D.C. case, dismissal of the Florida case, dismissal of the Georgia case, dismissal of the New York criminal case. And I would argue the logic of it would apply to the civil proceedings because it both concerns acts as president, both New York civil cases, at least the E. Jean Carroll case. And they could kick out all the nonsense by just saying, no, you can't indict a president without going through an impeachment and conviction process, at least for anything he did while president.
You mean the Stormy Daniels hush money payment?
Correct. Stormy Daniels New York case, because including here, they admit that Jack Smith, the prosecutor, admits the illicitly authorized prosecutor, the illegally funded prosecutor, the deep state hack prosecutor, that he who misused and who already violated attorney-client privilege, already violated due process, already violated venue rules, which we'll get to in a second. These are, I assume, they're going to use discovery to bring a motion to dismiss on governmental misconduct grounds, based on attorney-client privilege breaches, based on breaches of Fifth Amendment rights, based on venue abuse with the grand jury. That happened because he kept going to a D.C. grand jury to develop evidence for a Florida case, based on the fact that he continued to use the grand jury as a discovery tool after indictment, which is also unauthorized. So, I mean, every ethics rule and legal principle you could violate as a prosecutor, Jack Smith has. Is achieving a record that even Andrew Weissman would have to be shocked by. One of the most corrupt prosecutors in American history, currently on MSNBC, and one of the key people was part of the corrupt Mueller team. The immunity grounds, because Jack Smith admits the centerpiece of the case is President Trump's initial decision while president to make the documents personal documents and to remove them from the White House. They're saying that act is the predicate for all the charges. Because it's the predicate for all the charges, if he's immune from that, the entire indictment must be dismissed. So immunity could solve all the problems. But otherwise, the government has a time frame to respond. Then they get a chance to reply. There may be additional motions based on additional discovery. Smith is trying to hide a bunch of discovery that the court is saying should be released and publicly disclosed. Clearly, there's more embarrassing information in there about conspiracy between the Biden administration, the National Archives, and the FBI and the Justice Department to try to entrap Trump related to all of this. So all of that combined will be additional grounds. Most likely this would be heard sometime in April in terms of a hearing date. Given the legal density and complexity of these issues, what I said from the get-go is it would be shocking for any case to reach trial before Election Day if it was done on a normal track. So you're going to have to ignore the normal track to rush it. I don't see the Florida federal judge doing that. The D.C. courts are trying to do it, but the Supreme Court can put a halt to that by taking the immunity case.
Well, and the New York case is going to be the federal one.
That's still going to be held trial in March on this ridiculous Stormy Daniels case. But if the Supreme Court were to take immunity and grant immunity, then the New York court would have little choice but to dismiss that case.
There is a distinction, just to play devil's advocate, between immunity for clearly presidential acts and then immunity for non-presidential acts. Insurrection would not be a presidential act.
I think if you're doing it in the capacity while you're president, I think there's no doubt it's a presidential act. I think calling it anything else a non-presidential act.
Just to take the straw man argument, murdering the chef because you don't like the dinner is not a presidential act. But
if it's done while you're president, typically because the problem is once you start drawing that line, that's a very hard line to draw.
True, but
anything you do as president is going to impact your presidency. It's going to impact whether it's personal or presidential. So that if you're going to limit it to their official duties and tasks. They're given as broad a range as is imaginable in terms of their executive duties. They're given a lot broader range than a senator or congressman is, or a judge is, and they've considered that those people are doing immune acts when they make personal comments about personal matters. So if we're going to have consistent law on immunity, all this would apply to the president without doubt. But here, you don't even have to go there because all of these things are clearly within his official duties. I mean, the D.C. court had to go through all these, well, it's ministerial versus discredit, all this ridiculous nonsense to try to pretend that commenting on your own election to the White House as president of the United States over the most consequential election that is under your jurisdiction is somehow not within your duties to talk about. That's just ludicrous. We don't really have a situation or scenario where you can say it's truly personal. But in almost every context, they've said that this is within immunity. So they would have to eviscerate their own immunity doctrines to suddenly remove it from Trump.
Robert, I found it, and I turned the volume on.
I can give him a pool. All right, now, kids, I don't want anyone swimming in this pool unless there's a lifeguard on duty. Duty.
No court has the power to enjoin the president for any reason. They cannot issue an injunction against the president. How then can they indict the president? How then can they criminally prosecute and punish the president? It makes no sense. They would have to go back on all of their immunity claims.
In the absence of an impeachment and conviction.
Right, correct. That's the real determination as to whether something was presidential or not. If it wasn't, then you'll be impeached for it and you'll be convicted for it through the political processes that the whole country has a say in. The goal is to avoid a private citizen like Jack Smith having the power to imprison a president or any other local prosecutor like a Letitia James, like a Big Fanny. We're seeing why this power has to be used in the way it is used.
That much is a perfect segue and a perfect explanation as to how the rules were in place and why they were in place. I would just say, look, to steelman it, yes, you're right. Like, murdering your chef because you don't like the dinner is not a presidential act, as most would say, but there's a process for it, and if that's the case, then you go through the process. You don't get acquitted by the Senate for murdering your chef because you don't like the food under normal circumstances. If you do, you got bigger problems. And then the problem is they're not impeaching, but they're indicting and they're convicting at a state level, at a federal level, in the absence of and even in the face of an acquittal on impeachment. And we're seeing what's happening. Do we go to the Big Fanny now?
Yeah.